So did you want me to call MIDC or should I just go
So
with?
we have MIDC. Paul Hubble is MIDC, but we just need
Oh,
we just need the jail now.
okay. They're putting them in. Okay,
Got
thanks.
it. Thanks. And actually, I'm going to bring he and Miss Flynn in just to make sure he had time to talk to Mr. Salvatore. Oh.
Tour while she's off.
Hi, Mr. Hubble. They're getting Mr. Salvatore now. Do you need any time to speak with him when he gets here?
I've already talked to him. I just
Okay,
want to
very
put
good.
my suit coat on, please.
Oh, yeah. That annoys you?
He knows I'm in trouble.
Okay.
That doesn't mean it.
Your Honor, since it looks like we have a minute,
Yeah, Mr. Hubble, go ahead.
would it be possible for me to have a short breakout room with Miss Flynn? I've got the request and warrant for the probation violation, but I don't have any underlying documentation. I just wanted to speak to her about what her position is and what
Sure.
information she might have.
Yeah, I'll put you both in there. Hang on one sec.
Thank
Thank
you.
And actually, while they're doing that, we have everybody for the 1:15. Kristen, are you okay going into work?
Sure.
Okay. All right, good afternoon, everybody. Mr. Corcoran, good afternoon again. I know we're a few minutes early, but we're waiting for the Grand Traverse County Jail to do my arraignment at 1 o'clock.
Okay.
Since we seemingly had everybody for the 1:15 and courts never get to go early, I figure we might as well take you guys. So
Well, thank you, Your Honor.
let's see. Okay. Let me just make sure, Mr. Brock, can you see and hear me okay?
Yes, Your Honor. Sorry.
Okay. No, that's okay. I just wanted to make sure since we were a few minutes early. But let's go on the record and file 25-5412-FH, People of the State of Michigan versus Raymond Arthur Welsh IV. And sir, are you Mr. Welsh?
Yes, sir.
Okay, good afternoon. And Mr. Corcoran is here on his behalf. With him on the Zoom feed, Mr. Brott is appearing on behalf of the people. And we are set for a competency hearing. First for Mr. Welsh and Mr. Corcoran, I apologize for the confusion. For my Antrim day on Monday, this hearing was originally on the docket for, I think it was 8:30 or 8:45, I forget which. And then Mr. Corcoran came in around 10:30 and said that the notice had said 10:35. And I did check the notice and confirm, Mr. Corcoran, that you are correct. So I'm not sure what the confusion was, and I apologize for that. But regardless, we do have the report from the Forensic Center. I did have a chance to review that. Mr. Brott, let me start with you. Did you all have a chance to review that? And what's the position of the people?
I have reviewed it, Judge. I would ask the court to enter that report into the record. And I'm not going to seek an independent evaluation with regard to that.
Okay.
This time.
Mr. Corcoran, would you all stipulate to the admission of that report?
The defense will do so, Your Honor. Yeah.
Okay. And as I mentioned, I did have a chance to review that and the finding of, let me get to the end, Dr. Kanoy was that Mr. Welsh is not competent to stand trial. Also the finding was that despite the time permitted under the statute, that he would not be able to be made competent, for example. And based on the reasoning provided, it had to do more with mental health concerns and deterioration, not a medication issue, which I think is what we more commonly see. And so based on that, the court would make a finding that the defendant is incompetent to stand trial and is not restorable. There would be a substantial probability that the defendant, if provided a course of treatment, will not attain competence to stand trial within the time established by law. So, Mr. Brott, if you all could provide the appropriate order, and I would indicate that the box will be checked relative to a petition, but given that the court has the least information out of anybody, I would indicate that that's an indication to the people that if they think it's appropriate, they should submit the petition, and only under those circumstances, a petition is not being ordered by this court, simply a review by the people to make that determination. So, Mr. Brott, if you all could prepare that order and submit it for my signature, please.
I've actually already e-filed it this morning or around
okay.
noon. So It'll
And
probably hit you soon, Judge.
I was going to tell the court that we'd stipulate to the order that he filed earlier today, Judge. So,
Okay, very good. My thanks to you both. And then we should be all set after that. So thanks, everybody.
Your Honor, I
Thank you,
just
Your Honor.
had one last question. My client is fitted with a tether, and I'm not sure if whether, we should address that now or subsequent to when.
Well, after the court signs the order, I would suspect that Mr. Brott would be filing a nollie based on the finding of incompetence. I mean, that's his decision, obviously.
Sure.
And at that point, the bond would be canceled. And so then arrangements would need to be made with community corrections in order to return that. I'm not sure if that can be accomplished by going through the Antrim County Jail, or if it would have to be done with community corrections. They would provide that answer.
Okay, fair enough. Thank you, Your Honor.
Yep.
Appreciate
Thank you all.
Thank you.
And then, Judy, could you just give the jail a call one more time? It looks like we still don't have them. So,
I did, and they said
Oh.
that they were gonna bring him in. That's what they said the first time too, so.
okay.
I will need a short breakout room with Mr. Salvatore, please.
Okay.
Based on the information and my discussion with Miss Flynn.
Sure. And close these then. Hi, sir. Good afternoon. Are you Paul Joseph Salvatore?
I am, yes.
Okay. Good afternoon. Mr. Hubble is here from MIDC for your arraignment. I know the two of you had a chance to speak, but he had the chance to talk to Agent Flynn in a breakout room, and then he wanted to have another opportunity to talk with you before we got started, sir. So I'm going to put the
Okay.
two of you in a breakout room, and then we'll get started when you all get back. Okay?
Great, thank you so much.
Okay. Yep. Just stand by. And Mr. Hubble, take all the time that you need.
Thank you, Your Honor.
Okay.
I haven't greeted you yet today, Judge. Happy Friday.
Thank you. Happy Friday to you.
Thank you.
Let's see. Okay. Thought I clicked the wrong person there, but I think I got the right one. Folks, are you here to observe one of the hearings?
No, but we were told Titus Van Dusen was going to be at 2, but there was 2 there, so.
Oh, Mr. Van Dusen's case? Yes, 2:30 is correct. Okay.
We didn't know there would be more trouble. Lost.
Well, either way, it's a relatively small building, but between the floors, it is possible, sir. So you're free to wait in the courtroom. I just wanted to make sure that we had you here for the right one.
Right, is it?
Currently, it's 20 after 1. Okay, Mr. Salvatore, can you see and hear me again? Okay.
I can, Your Honor, yes.
Okay. Let's go on the record then and file 24-14935-FH. It's People of the State of Michigan versus Paul Joseph Salvatore. Mr. Salvatore is joining us via Zoom from the Grand Traverse County Jail. Mr. Hubble is here on his behalf as MIDC, and then Agent Flynn is here on behalf of the department. And we are here for an arraignment on a probation violation allegation. Just to note, I did put a note on the warrant when I signed it, but given the original charge in this case, given it was the consumption of alcohol, the court is going to treat this as a non-technical probation violation, and then I provided the statutory cite. So, Mr. Hubble, you did have a chance to talk to Mr. Salvatore, so let me start with you in terms of how we'll be proceeding.
I did talk with him and I discussed with him the allegations on the probation violation, as well as his ability to ask for a hearing and ask for the assistance of an attorney. He wants to take responsibility for the violation. I also spoke to Ms. Flynn, and it sounds like she is going to be amending the petition, and I have discussed that with Mr. Salvatore. Apparently there was a condition 4 point something about not to act in a violent, threatening, intimidating manner towards anyone, and he will take responsibility for that as well. In terms of, I also understand from talking to her that her recommendation is 15 days in jail, no contact. That would give her enough time to line up with jail diversion, place for him to stay and get him into some treatment, and he would like to take advantage of that.
Okay, Agent Flynn, is that accurate that the department would, assuming that we get a plea, would like to proceed to sentencing today with the terms that were just outlined by Mr. Hubble?
Yes, Your Honor. So based on the PPO that was authorized earlier this week against Billy, in review of his originating probation order, he does not have a 4.18, which is that he shall not engage in any of assaultive, abusive, threatening, or intimidating behavior. Obviously, because the PPO was authorized, then we would also need a 4.5 condition where he can't have contact with her. If we could move forward to sentencing, obviously we'll let the court's discretion as to how much time. However, I can work with jail diversion and try to get something set up. This incident now has taken his residential stability. I've spoken with his parents who do not want him at their house either. So currently he would be considered homeless. And it is my understanding that it wasn't just this singular date where he had consumed the alcohol. So I feel like we probably need to open up the door with jail diversion for maybe more treatment and sober living so that he has a stable place to stay. Thank you.
Okay. So, Mr. Salvatore, let me sort of go over kind of where we are with that discussion. I know you had the chance to talk to Mr. Hubble, and presumably he went over with you his discussion with Agent Flynn. But I want to make sure you're aware of a couple of things. The first is that you would be entitled to a hearing, of course, on this allegation, and it would be contested, meaning that the hearing, we could assign an attorney for you. They could represent you at that hearing, challenge any of the evidence and whatever it may be. The other part is that for the listed violation, and that's the consumption of alcohol, because the original offense here was an OWI third, that actually is a non-technical probation violation. And so the maximum penalty, of course, would be the statutory maximum less any credit that you have. Now, obviously, what's been proposed is not that, but I have to inform you of the worst possible case scenario. So does that all make sense to you, sir?
Yes, it does, Your Honor.
And so what's been proposed, just so that I make sure that I understand it clearly, is that you want to waive your rights to have a hearing and be represented at that hearing. You would admit to the violation here. I think the way I would phrase it is the court would just take judicial notice of the PPO. And what we would do is add those provisions that were talked about by Agent Flynn. And then with the jail time, the idea is obviously not to lock you up and throw away the key, let's say. The idea would be to use that time as a punishment for the allegations here with the plea, but also an opportunity to use jail diversion to get you into some type of treatment program where the underlying issues can be more appropriately dealt with. So does that all make sense to you, sir?
It does, Your Honor, yes.
Okay. And so with that understanding, is it true that you wish to waive your right to have a hearing and admit to the violation here?
That is correct, yes.
Okay. Is it true, according to the allegations here, that on or about June 8th of this year, that you did consume alcohol?
As Ms. Flynn mentioned, it started a little earlier than that. I relapsed. I wouldn't say that I want to take advantage of this opportunity. I think I need it.
Okay.
So yeah, I relapsed, and I had gotten 2 years clean on April 16th. And I kind of felt that I had it under control, and that's kind of what happened. I thought that I was stronger than the alcoholism, which I know I'm not. So I think that some treatment and some sober living would be a really good reminder of that.
Okay, very good, sir. Thank you. Mr. Hubble, any additional questions for you?
No, Your Honor, thank you.
Agent Flynn, any additional questions for the department?
No additional questions, but I am trying to figure out jail credit.
Okay, I appreciate that. And then, Mr. Salvatore, to the allegation then that you did consume alcohol, or I'm sorry, I don't think I asked. Obviously, one of the terms of your probation was that you not consume alcohol. Is that true?
That is correct, yeah.
Okay. And to that allegation then that you did consume alcohol on or about, and it may have been before June 8th, but around that date, how do you plead?
Guilty, Your Honor.
Okay, I'll accept that guilty plea. I'll find that it's understanding, voluntary, and accurate. And in accordance with the wishes of the parties, we will proceed with sentencing. Mr. Hubble, beyond what's been stated, anything else for you?
I would ask, depending on what the credit is, if they can line up residential treatment and jail diversion before the 15 days, if he could be released from that and suspend any further additional time, that would be helpful. I think he understands that the relapse is something that he's got to take responsibility for and got to deal with responsibly, and I think he's doing that. I think whatever time he does get in jail would be adequate punishment, and I think the emphasis here is more on trying to get him back on track. If he had 2 years sobriety under his belt, then this should help him to get back on the right path.
Okay, thank you. Mr. Salvatore, any additional comments that you'd like to make, sir?
I would just like to thank Mrs. Flynn and Mr. Hubble, and that's it.
Okay, thank you. Agent Flynn, anything for the department?
Yes, Your Honor. I am calculating the jail credit to believe that he has credit from April 6th of 2024 to April 11th of 2024, which is 6 days. Then he has December 19th of 2024 to August 11th of 2025, which would be 236 days. And then, Mr. Salvatore, can you confirm, were you detained Monday or Tuesday night?
Monday evening.
Monday evening. So it would be 1, 2, 3, 4. So we'd have 5 additional days to that. So it would be 236 plus 11. So he's got 247 days credit.
Okay. And it's actually 246, Mr. Salvatore, because today doesn't count yet. So it's an odd thing of calculating. It's the days up until the day of sentencing. You still get credit for today. It's just because today isn't over yet. So just so you're aware, when I say a different number in just a moment, that's the only reason why. Okay.
Okay, thank you.
Okay. And obviously, I think, Mr. Salvatore, I think everybody has done a good job, including yourself, of explaining sort of how we got here. One thing that I would cover with you, and you used a word that it quite commonly is used in the criminal justice system when talking about addiction, regardless of whether it's alcohol or drugs. And I am not a word police or worried about political correctness with the way people talk. But I do stop people and ask them to use a different word. You used the word clean. And the reason that I do that, and it's not your fault, it's the way that all of us have talked for a long time who have been involved in the criminal justice system when talking about addiction, right? I dropped dirty, or I dropped clean, or I would drop clean. And the reason that I do that is because that implies that there's a morality to it, and that you're a good or bad person, even subconsciously. And it's the sobriety, or it's, there may have been a relapse or whatever it may be, but you had 2 years of sobriety. And that's a tremendous accomplishment that I don't want you to lose sight of. I mean, one day is impressive, 2 days, right? We build on it one day at a time, as you know. And complacency is unfortunately the thing we so often see take hold. And, that's what happened here, it sounds like, with the relapse. Now, that doesn't mean that there aren't other things that maybe need to be dealt with, and so be it. But as with most people, I think, that come through here, if we go back to all of the moments when whatever physical is alleged in whatever moment, so often alcohol is part of that. And it doesn't mean that alcohol caused that. It just means that there's something underlying that is released when the alcohol is consumed. And so hopefully the treatment can delve into both things. But certainly that's an appropriate response here. And the plan that was outlined, I think, is appropriate. I would note that the jail time that I assign Agent Flynn, as quickly as treatment can be arranged, I would suspend the balance of that sentence, even if it were today, Mr. Salvatore. Obviously, the focus here is getting the treatment, and the focus needs to be on that, of course. But I would note again that you do have 246 days of jail credit. That would be applied against any sentence that the court imposes. And so I would sentence you to 261 days in the jail. Again, you do have credit for 246. There will be no new fines, costs, or attorney's fees assigned for this violation. If there was a previous balance, that would be preserved. Additionally, the court will take judicial notice of the PPO, and I'm not making findings on whether anything is accurate or not, but out of an abundance of caution, the court would order that 4.18 be added, along with 4.5 for the no contact language, as well as the no assaultive behavior, et cetera, that Agent Flynn referenced. And again, if treatment can be arranged more quickly than the 15 days, the court would authorize the balance of the sentence to be suspended so that Mr. Salvatore could go participate in that treatment as soon as possible. Okay. Mr. Hubble, any questions for you about the sentence?
No, thank you, Your Honor.
Agent Flynn, any questions for the department?
No questions, just comment. I will get with jail diversion today. I'm not sure if they're still there. I will go to the jail here shortly and attempt it. If not, Mr. Salvatore, I'll get with you early next week because I'll have Sarah work with you to get into treatment, okay?
Yes, thank you so much.
Okay.
Thank you.
Good luck to you, Mr. Salvatore. Thanks, everybody.
Thank you, Your Honor.
Have a great day. Thank
You
you.
too, Mr. Hubble. Thank you.
Thank you. Have a good day.
We'll bring in Mr. Atwood and Mr. Johnson. Gentlemen, good afternoon. Mr. Johnson, I don't see your client in the waiting room. Have you had any conversations with Mr. Lindsay?
I have. He's in jail.
Oh, that's right. I'm sorry. Of course. There we go. Mr. Lindsay, can you see and hear me okay? Mr. Lindsay, can you hear me?
I can hear you now clearly.
Okay, very good. Let's go on the record then and file 24-15011-FC. It's People of the State of Michigan versus Demario Lindsay. Mr. Lindsay is joining us via Zoom from the Grand Traverse County Jail. Mr. Johnson is here on his behalf, and Mr. Atwood is appearing on behalf of the people. We're here on Mr. Johnson's motion to withdraw as counsel. I did have a chance to review that, but Mr. Johnson, anything else for you on that one?
Your Honor, I don't take this lightly, and I don't ask to do this. I think this is the second time I've ever done this. But there's been a breakdown in communication where it's just not getting home. My counsel to Mr. Lindsay, and I think for his fairness and defense, I've talked to him about having somebody else explain things. Perhaps somebody else sees things very differently than I do. But on a number of matters, I feel like I'm continuing to offer counsel, and confusion persists. And for that reason, and the one other time I've done this, I know it did work out well, where somebody else explaining things differently was helpful to the client. And at this point in time, I don't want to put Mr. Lindsay at any sort of disadvantage based on our breakdown in communication. So that is the reason that I reluctantly filed this motion to withdraw. I do believe it is in Mr. Lindsay's best interest.
Okay, Mr. Atwood, do the people have any comment on the motion?
We do not, Your Honor.
Okay. Mr. Lindsay, normally I don't directly talk to the defendant about this issue, and I just want to explain why for your benefit, sir. Whatever conversations you've had with Mr. Johnson, that's of course privileged information, and so I don't want either of you to get into that. Generally, the court does trust the attorneys when they say that they need to get off of a file or they think it's appropriate. It is such a rare case that that may be, in fact, the right way to go. Now, what I'm not going to do at this point is I'm not going to move the trial dates. I want to keep your case moving. I want to give whoever is assigned to your file the opportunity at this point to take a review of the file, and that may be something that they want to take up in the future on your behalf, but I want you to be able to chat with them before that's done. So does that all make sense to you?
Yes, sir.
Okay, so the court will grant the request for Mr. Johnson to withdraw from the case. I will order that another MIDC attorney be appointed based on the prior finding of indigency. Again, at this point, we will keep the trial dates and expect to proceed on that front. If the new attorney feels that they need additional time, they can talk to Mr. Lindsay about that and then file a motion so that the court can review that and the people can have an opportunity to respond. Mr. Lindsay.
And I got how much time do I got to appoint me attorney to retain one? I got time for that too, right?
Oh, yes, sir. You can always retain an attorney on your own behalf if you wish. I just want to make sure that you keep having an attorney, so to speak. And then what would happen is if you retain an attorney, whoever gets appointed by MIDC, they together would just file what we call a substitution order. And then whoever the retained attorney is would take their place on the case. Does that make sense to you?
Yes, sir.
Okay, very good. Then we should be all set. Thank you.
Your Honor.
Yep.
Oh, I'm sorry, Mr. Atwood.
Would it be possible or advisable to set some sort of status conference? Given that we're a month out from trial, I spoke with the Detective Bureau this week, who are about ready to go serve subpoenas out and spin everything up. And I'm just hesitant to put them through all that if we're going to give time to retain an attorney. The feasibility of going to trial with, I think we had something like 15 witnesses in 4 days in a month was sort of an indefinite, we'll see how it goes timeline. Makes me a little nervous.
Sure. So what we'll do is we'll set a status conference approximately 10 days out. That should be enough time, Mr. Lindsay, for the new MIDC attorney to get appointed on the case, meet with you and review everything. Certainly, if you want to retain somebody, again, that's appropriate. And then we can use that status conference to sort of check in to see where we are, Mr. Atwood. And then if any decisions are going to be made about adjourning or whatever it may be, we can talk about it at that time.
Perfect. Thank you, Judge.
Okay. Yep. Thank you.
All set.
Yes, sir, Mr. Lindsay, you're all set. I apologize. You're free to go.
So I have attorney coming to see me and talk to me?
Yes, sir. Generally, it should be within, I think, 3 business days is generally the turnaround. But now that's once they get appointed. So I have to sign the order from today. It goes to Mr. Jarbo's office, and then they'll appoint somebody new. So it may not actually be 3 days, but certainly by mid next week, somebody should be in contact with you.
All right, appreciate it. Thank you very much.
Yes, sir. Have a good day. Just gonna bring in Ms. Claxton, Ms. Johnson first. Agent Johnson, Ms. Claxton, good afternoon. Ms. Claxton, it looks like we have Mr. Minor in the waiting room. Do you all need a breakout room before we get started?
No, we were able to speak. Thank you.
Okay, very good. Let's see. Hi, Mr. Minor, good afternoon. Can you see and hear me okay?
Hello.
Hi, sir. Can you see and hear me okay?
Yep.
Okay, perfect. Let's see. Okay. Let's go on the record then in file 25-15301-FH. It's People of the State of Michigan versus Isaac Minor. Mr. Minor is joining us via Zoom. Ms. Claxton is here on his behalf, and then Agent Johnson is here on behalf of the department. And we are set for a probation violation this afternoon. Ms. Claxton, let me start with you in terms of how we'll be proceeding then.
Thank you, Your Honor. Your Honor, unfortunately, the allegations in the probation violation did result in new charges for Mr. Minor. Those are pending in Manistee County. So at this time, we would ask for an adjournment to protect Mr. Minor's Fifth Amendment rights as to the new charges.
Okay. Agent Johnson, any objection to adjourning on that basis?
No, I don't, Your Honor, but I would like to address his GPS curfewing before we are done today.
Okay, that's perfectly fine. We can talk about that in just 1 second.
Thank you, sir.
And so, Mr. Minor, Ms. Claxton on your behalf has requested to adjourn the probation violation hearing. And that's because, and this happens often, I guess is the way I would phrase it, where allegations that may result in probation violation allegations can sometimes result in new charges as well from the behavior. And so generally what we will do is adjourn the probation violation matter out until the new case or cases are done. That way it ensures that your constitutional rights are protected to the highest degree on the new case. So does that make sense to you?
Yeah, it does.
Okay, and so we will adjourn the PV. I think, Ms. Claxton, rather than going without a date, because the charges are in a different county, we'll set it out approximately 60 days just so that we can keep checking in so that we don't lose track of his file here. And then Agent Johnson, you wanted to discuss an issue relative to bond. Go right ahead.
You had issued earlier for him to be on the GPS curfew monitoring, and I feel that he has superseded the requirements for that. He has reported as instructed. He's completed treatment. He tried sober living, and that went okay, but he found employment. He has a new job. He is in Ludington now, correct, Isaac?
Yeah, I'm living with my boss.
Yep, he lives with his boss. He's has a new job. He's doing everything above and beyond and that we've anticipated and expected from him. He's did a complete turnaround. And I was wondering if we could just however that works, take the GPS monitoring off at this time, or how's that work, sir?
Okay, Agent Claxton, I assume there's no, or Ms. Claxton, I assume that there's no objection to that.
No, Your Honor, Agent Johnson actually did my own argument for myself today.
The court will approve that request to remove the GPS tether. What we'll do is convert the term, and I'm not sure what the exact term of your probation is, Mr. Minor, but we'll convert it. We'll convert it to just say that GPS tether will be at the discretion of your agent, and so we will discontinue its official requirement at this time. And Mr. Minor, that would just mean if there's an issue in the future, which we don't expect, I just always like to have the provision there. Right. That way she can respond by putting that in place immediately rather than having to come get an order from the court. So does that make sense to you, sir?
Yeah.
Okay. And with that, I don't want to lose track of congratulating you on the change in behavior. I mean, that's why the request is granted. It sounds like everything is headed in the right direction now. Hopefully that can continue despite the new case and despite these allegations. So make sure that you just stay on the right track, sir, and hopefully everything will resolve itself appropriately. Okay?
Of course. Thank you.
Okay. Agent Johnson, anything else for the department?
No, Your Honor. Thank you.
Ms. Claxton, anything else for you?
No, Your Honor.
Okay, we're all set on that one. Thanks, everybody. You're free to log off.
Thank you.
Thank you.
Looking for
Hi,
the
sir.
damn remote in. Yeah, I was blocking it.
Hi, sir. Can you see and hear me okay? Sir? Can you see and hear me?
Yes, I can hear you. Yep.
Okay, what's your name?
Jacob Smith.
Okay, thank you.
And Judy, we actually have a breakout room.
Yep, yep. I'll put you in there right now.
Thank you so much.
Mhm. Mr. LeBlanc, can you hear me?
Yes, I can.
What case are you here for?
Case number, 250016661.
Mr. LeBlanc, good afternoon. Are you on Mr. Smith's case?
Yes.
Yeah, okay, that's the restitution hearing at 2 o'clock, Judy. I think Mr. LeBlanc is one of the victims from the case.
I am.
Okay, thank
Yep.
you, thank you.
Yep. Sorry, sir, those names don't appear in the court records. That's why I just assumed based on the nature of the hearing, so.
Okay. Yep.
Okay, yep. We'll put you back in the waiting room and then we'll bring you in once we're ready for that one, okay?
Oops. Hi, person labeled Kyocera E7110. What's your name?
Say it again. Mike Richardson.
Okay, are you here for, what case are you here for?
What case are you here for?
And my bike was, I had a moped that was, ran over.
Okay,
That's
Right.
also that's Mr. Smith's case as well, Judy.
thank you. Okay,
Yep.
thank you, sir.
Okay.
Let's see. Mr. Smith, can you see and hear me okay?
Yes, sir, I can.
Okay, good afternoon. It looks like we're just waiting for somebody from the prosecutor's office. So just bear with us a few moments and then we'll go ahead and get started.
Okay.
Yeah.
Miss Fauch, can you hear me?
Yes,
Okay,
I can.
just
Yep.
Okay, are you here for the Smith case?
Yep.
Okay. Thank you.
And folks, again, good afternoon on Zoom. I don't think everybody was quite in the Zoom hearing yet. So we have Mr. Smith here as well as his attorney. We're just waiting on somebody from the prosecutor's office. I'm guessing somebody's going to come over in person because we have a sentencing at 2:30. So just bear with us for a few minutes. And as I say that, Mr. Atwood walked in. And so we'll get started in just a moment.
Okay.
And actually, so before that, Ms. Claxton, would you mind unmuting for a second? We don't need to go on the record for this. So, Mr. McCann, good afternoon, sir. Ms. Claxton, if you could pretend to be Mr. Kane for just a moment. Your sentencing was scheduled for this morning, sir. And so originally, because you did fail to appear, the court authorized a bench warrant. But hang on one second. Hang on. I saw you walk in when I ran into you in the lobby. And so just so everyone's aware, a new disposition order was created. What we're going to do is adjourn your sentencing date, and then we'll set a show cause rather than doing a bench warrant. Okay. So make sure that you contact Mr. Kane this afternoon. He'll get the new disposition order, and then he should be updated beyond that. Okay. Okay. You're all set, sir. You don't have to stay in the courtroom.
Free to go right now.
Yes, sir, you are.
Okay, right now.
Okay. That's perfectly fine. Thank you.
Thank you for.
Let's see. And then, Mr. Atwood, are you all set?
I think so, yeah.
Okay. Let's go on the record then and file 25-15482-FC. People of the State of Michigan versus Jacob Smith. Mr. Smith is joining us from an MDOC facility. Ms. Claxton is here on his behalf via Zoom. Mr. Atwood is in the from the prosecutor's office, is in the courtroom. Again, we have an in-person sentencing at 2:30. And then we have a number of folks associated with the case joining us as well. We are set for a restitution hearing. And Ms. Claxton, I'll start with you. Have you all had an opportunity to review any requests in this case, and what's our status?
Your Honor, we have had an opportunity to review some documentation. I've had several conversations with Mr. Atwood this week about the restitution, and it sounds like we're still missing some information. I'm hopeful that we can come to a resolution, but I think we still have questions as to insurance claims and payouts and that sort of thing. So I don't think that we're ready to agree to an amount today, but I'm hopeful that we could potentially in the future.
Okay, Mr. Atwood?
I think that's correct, Your Honor. I've had several conversations with Ms. Claxton. Our office has had conversations with Mr. LeBlanc and Mr. Richardson. My understanding, I guess just to kind of give the court a status report on Mr. LeBlanc, it looks like there was a complete payout by Progressive after a subrogation request to the defendant's insurer, State Farm. They basically totaled out the vehicle. There was a subtraction for a salvage value. The victim kept the bike. But there's a remaining question about whether or not there was a deductible on the amount paid to the victim. There was a payout in the amount of, or at least a payout from State Farm to Progressive in the amount of $1,648.23. We have verified that the victim did receive a check from Progressive in the amount of $1,000. But there may have been a deductible amount. And so we're trying to iron out that, whether that was the $648.23 that was left. If so, that would be, I think, available in restitution to the victim. Regarding Mr. Richardson, we're still trying to arrive at a value on that motorcycle or scooter rather. We have some values for 2022 scooters that are around 1,100, but it sounds like the scooter in question here was a 2006. Which we have not been able to find good values on. So we were just able to talk to Mr. Richardson, I think, recently, but we need to arrive at a value he's comfortable with and see if the defendant would be willing to pay that amount. The other folks involved, I don't believe we've had conversations with, or they haven't returned calls. So we're just left with those two. I think we're close, but I don't think we're ready to pull the trigger on an agreement at this point.
Okay. And for the folks online, just so you're aware, oftentimes it can take a while to iron out restitution details. There are certain values that are permitted under the law, and it doesn't always operate to full market value, unfortunately for folks, but that's the way that the law is written. There are also some things that can be recovered under the victims' rights statutes and some things that cannot. Plus, with Mr. Smith being at an MDOC facility, that can make it difficult at times, I'm sure, for Ms. Claxton to be able to contact him and work out some of the details. So essentially what you heard is the parties are requesting some more time to iron out those details, which is perfectly appropriate. So we will adjourn the hearing to give them time to do that. And then if we need to hold a hearing, of course, that's perfectly fine. But if we can iron out the details, or they can, and a resolution can be reached to everyone's satisfaction, of course, that's the ideal scenario. So make sure that you all just stay in contact with the victim rights folks at the prosecutor's office. And then if you're on the call or in the courtroom for this case and heard that you were having trouble being contacted, make sure you reach out because they may have the incorrect phone number or something along those lines. Okay. Ms. Claxton, anything else for you?
No, thank you, Your Honor.
Mr. Atwood, anything else for the people?
No, Your Honor, thank you.
Okay. Thanks, everybody. We're all set on that one.
What time you want that reset or just?
I'll put a note on there. You can just. Thank you.